Mr. Purvis.
My lords, lady, I think the time has come to address the various strands in the arguments put in the judgment of the Court of Appeal and by my learned friends on this appeal in answer to our case of straightforward lack of enablement across the claim.
I'm so sorry, Mr. Purvis. You just need to speak a little bit louder for me anyway. Sorry.
And the first of these is this issue of a principle of general application, which is so central to my learned friends' submissions and indeed the judgment of the Court of Appeal. And can I say this at the outset? We struggle sometimes to understand quite what a principle of general application is or how one identifies one. But the first point is that whatever a principle of general application may be, it can't be a substitute for the requirement of enablement. So once you're told what the principle of general application is, if you still can't perform the invention across the scope of the claim, then it's still invalid. And the principle of general application, by definition, hasn't helped. Now, there may be cases where the principle of general application is, by its very nature, such that the skilled person is, as a result of the disclosure of it, technically enabled to produce everything across the scope of the claim. But identifying it as a principle of general application is not actually particularly helpful. Because the real question is simply one of fact. Can the skilled person, armed with the disclosure of the patent and his common general knowledge, actually do it? And we submit, therefore, it follows that the only principles of general application which are going to be relevant and helpful on the subject of sufficiency are principles which are tools of enablement in themselves. And when the question before the court is whether the skilled person is able to make the products across the scope of the claim, an enabling principle must be one which actually enables the making of those products. By contrast, a principle, theory, or discovery about the technical benefits that products would have within the claim, if they could be made, doesn't help on enablement either. It isn't an enabling principle because it doesn't allow the products to be made. Might be relevant for other reasons, like obviousness, possibly, but not for Article 83. The judge stated, the trial judge, reflected this proposition brutally simply, we submit, in a single sentence of his judgment, talking about the reverse chimeric locus. If your lordships have got the trial judgment at C2 tab 5, at paragraph 257, MS 333, worth just perhaps starting at the beginning of paragraph 257, including the whole subject matter, and he's talking about the 287 patent, was not capable of being performed at the priority date without undue burden. The difficulty doesn't relate to some hypothetical puzzle at the edge of the claim, which is a phrase sometimes used in patent cases for non-enablement of fairly irrelevant extreme cases, but rather to the central disclosure of the specification, the amounts of genetic sequence it contemplates. And what he then goes on to say, 5 lines up from the bottom of that paragraph, reflects the argument that's still being pursued. I do not accept that all embodiments within the claim are unified by a single principle of reverse chimeric locus. This is not a principle that enables the method to be performed. Rather, it's the result of successfully carrying out the method. When he was talking in the context of Claim 1 of the 287 patent, which is actually a method claim, but a fortiori, this is not a principle that enables the products of Claim 1 of the 163 patent to be produced. Rather, it is the result of successfully producing them. So it doesn't help on enablement. Looked at another way, the mice comprising the reverse chimeric locus are the target provided by the patentee to aim at. The target does not provide the bow and arrow and the rangefinder. And the fact that the skilled person might just about be able to hit the least desirable edge ring of the target, I can never remember what colour that is, doesn't mean he's enabled to hit the whole of it. And these submissions are, we submit, backed up by the decisions of the Technical Board of Appeal, where one does find occasional references to principles.
Just before we do, so would you say that if he'd been talking about Claim 1 of the 163 patent, he would have said the reverse locus is not a principle that enables the product to be made, rather it's the result of successfully making the product?
Absolutely. That is exactly how he would have expressed it in relation to 163. It must inevitably be correct. Yes, the TBA does and has occasionally referred in the context of enablement to concepts or principles. And if we look at some of the leading cases, we will see that always those are tied to their function and ability to enable the production of products or the use of methods falling within the claim. We could start with detergents Unilever at A4, tab 34, between pages 8 and 9. That's MS 2348 and 2349. First of all, at the top of page 8, 2348, you will note in the board's judgment the criteria for determining the sufficiency of the disclosure are the same for all inventions, irrespective of the way they're defined. So we have structural terms of their technical features or by their function, and then we have the famous statement as to full enablement. And we then see one turns to the top of page 9, MS 2349, there can't be a clear-cut answer to the question of how many details are required to allow its reduction to practice from the comprehensive whole ambit of the claim. So since the question can only be decided on the basis of the facts of each individual case. Nevertheless, it is clear the available information must enable the skilled person to achieve the result within the whole ambit containing the respective functional definition without undue difficulty, and that therefore the description with or without the relevant common general knowledge must provide a fully self-sufficient technical concept as to how this result is to be achieved. That perhaps is a hint at principles, self-sufficient technical concepts as to how the result is to be achieved. And the word how is critical, not self-sufficient technical concepts as to how good the result would be if you could achieve it. And then it goes on therefore to be established whether the present specification discloses a single embodiment or a technical concept fit for generalization which makes available to the skilled person the host of variants encompassed, etc. And in the end, as you see at the bottom, the above definition is no more than an invitation to perform a research program. So a technical concept fit for generalization that makes available is some kind of principle which is properly enabling. It is therefore merely a tool of satisfying the fundamental test. And we see the same approach in the mycogen case, which I don't think we've looked at before, which is an A4 tab 35. And one sees here at the top of page 19, in the context of Article 83, A4 tab 35, page 19, MS 2384. Again, we're looking at the way in which an invention can be described in an enabling way. In certain cases, a description of one way of performing the claimed invention may be sufficient to support broad claims with functionally defined features. For example, where the disclosure of a new technique constitutes the essence of the invention and the description of one way of carrying it out enables the skilled person to obtain without undue burden the same effect of the invention in a broad area by the use of suitable variants. So if you give an example and then you give a new technique, and the new technique is factually enabling, then that may be satisfactory. But this isn't a substitute for the test, it's a way of satisfying the test. The test hasn't changed. And towards the bottom of that page, they repeat about 10 lines up. However, in all these cases, the guiding principle is always the skilled person should, after reading of the description, be able to readily perform the invention over the whole area claimed without undue burden, etc. So where general methods, where general techniques, where new techniques, principles are talked about in the TBA, they are tools. The test remains the same. Exon we've looked at. The principle didn't matter in Exon, whether it was in fact a novel, an inventive contribution for the inventor to say you will reduce cold filter plugging by using wax crystals which are less than 4,000 nanometers, because he hadn't factually enabled. It didn't make any difference that anything within the claim would plainly benefit from that principle, nor did it matter whether the principle was a novel invention for which the patentee was responsible. I wasn't going to retake you to that passage, which is 3.6, paragraph 3.6 on MS 2332. But it is perhaps at this stage worth going to my learned friend's written case, in which they try to square the result in this appeal with Exon. And they do that in paragraph 85, which is MS 153. It might help actually if you just had Exxon to hand as well, just in case. That's at A4, Authorities 4, tab 33, MS 2319 onwards. And what Regeneron say is the important distinction between Exxon and this case is that whereas in Exxon the applicant had discovered only one way of making smaller than 4,000 nanometer crystals and attempted to patent every way of making such crystals, in this case, etc. For a start, this is a mischaracterization of the claim in Exxon. The problem in Exxon was not that it was a method claim and that the inventor was seeking to patent every way of making crystals. As we see from page 1 of Exxon, MS 2321, Exxon was a product claim to distillate fuel oil with certain wax content and with wax crystals at a particular temperature, having an average particle size less than 4,000. So just as here, the applicant was attempting to patent every fuel oil with crystals of any size less than 4,000. They go on to say, in this case, the patentee has discovered, perhaps predicted would be a better word, that in every case in which the constant regions are left murine and only the variable regions are replaced with human DNA, the mouse will not be immunologically sick. So this is the benefit which they say everything within the claim will have. It isn't the manufacture of anything within the claim. And then they assert, remarkably, the patents can therefore be carried out across the entire breadth of their claims. It is a remarkable statement because, of course, the discovery of a benefit which the products or the mice would have if you could make them does not mean that you can make them. It simply doesn't follow as a matter of logic or common sense, nor, in fact, is it true that the patents can be carried out across the entire breadth of the claims. We know for a fact that they cannot. And then they say the fact that the specification doesn't enable the replacement of large sequences of DNA is irrelevant because the patents are not about techniques for replacing any particular amount of DNA and make no claims in that respect. Well, Exxon didn't make a claim to any particular technique. And to say it's not relevant that we can't make products across the scope of the claim because that's not what the patent is about, entirely divorces, contrary to the law, the content of the claim from the inquiry under Article 83. We submit this paragraph reveals in its full nakedness the inadequacy of Regeneron's argument on breadth of claim sufficiency.
You presumably say that the immunological health of the mouse isn't in fact part of the claim at all?
No. No. Contrast the second medical use claims where that is absolutely central to the inquiry. But again, even in the second medical use claims, there is a further inquiry, perhaps an initial inquiry. Can I actually make the chemicals which are said to have this effect at all? So it's a dual requirement in those cases. Here, as it happens, they're pointing at something which is not a feature of the claim at all. The Court of Appeal also missed the point about Exxon. Interestingly, if one takes the judgment of the Court of Appeal at C2, tab 2, 220 onwards is the passage where they consider Exxon. That's MS 224 to MS 225. You will see at 223 they quote 3.5, though interestingly they never go on to quote the passage that we've looked at from 3.6 about the irrelevance of the general principle. But note at 224 they appear to be treating Exxon as if it were a method claim. The insuperable problem was that the claims extended to the use of any additives, but no information was given which would enable a skilled person to perform the invention with additives other than those described in the specification. Again, additives were not part of the claim in Exxon at all. The claim was about the fuel oil with its range of wax crystals. So it wasn't because a range of additives were not disclosed that the claim monopoly was not justified. It was because the products within the claim simply couldn't be made across its scope. And the Court of Appeal therefore appear to have misunderstood the reasoning of Exxon, and in particular what the actual technical contribution of the claims was.
What do you think they mean in the last sentence when they say it didn't allow the skilled person to perform the invention over the whole range of a claim, and having regard to the technical contribution, this deficiency was fatal?
Well, they appear to be proceeding on the footing that the technical contribution was the fundamental problem, or the inability to, the mismatch between the claim and the technical contribution was the fundamental problem. As we pointed out in the case, that might be an issue for other articles within the EPC, like Article 84. But so far as Article 83 is concerned, we're only concerned with technical contributions which enable the working of the invention. And if all they mean is, as we perceive would be a proper interpretation of Exxon, because Exxon had not enabled the fuel oils across the range of the claim to be made, then it was invalid, then we wouldn't have a dispute with this. But
yes, it's the words in between the commas. I'm wondering if what their significance actually is.
Yes. I'm going to come on to technical contribution because it's another fundamental concept which is prayed in aid both by the Court of Appeal and by Regeneron on this appeal, as if it had some special meaning sitting outside the scope of the claim and didn't relate to things that had to be enabled. If I may, I'll maybe come back to that when I deal with technical contribution. It's a relatively short point, I think, when we look at the way it's been dealt with in the authorities of the TBA.
Yeah, but I mean, the implication of what they say in that sentence is that the inability of a skilled person to perform the invention over the whole range of a claim was not in itself necessarily fatal.
Yes, that may be what they're saying, and if so, we submit that's just a wrong interpretation of the case, because plainly what was going on there. I mean, even on the basic point about the non-enabled wax crystals under 1,000, it was a simple question of fact, as they said, whether it could be enabled And as we've seen in 3.6, the passage the Court of Appeal haven't recited, they specifically said that the underlying technical principle, whether or not that was inventive, was neither here nor there. Maybe, yes, also look at two of the other cases which my own friends cite. One of them I think we can take from their case. Because they refer to two cases of the enlarged board. So we're in C1, tab 7, at paragraph 71. First of all, which is at MS 148. Here, the enlarged board, by reference to the Nabisco case, which we'll look at, refer to the fact that in that case, the non-availability of some particularly effective strains is immaterial so long as other suitable strains are available to the skilled person. This meant that a claim directed to the use of the whole class couldn't be granted, although specific strains comprised in the class were not available to the public. In other words, although specific embodiments covered by the claim couldn't be carried out, it was allowable. But if we go on, what they're saying here is that the examples show the rule assumed by the referring board that an invention is not patentable because it covers an embodiment which doesn't fulfill the requirements of patentability is not without exception. Essentially, this was a case about something rather different, which is whether you could maintain a claim which included within its scope something which was actually not patentable. And by parity of reasoning, they said, well, in sufficiency cases, there may be exceptions where there are certain things which are within the claim that can't be done. We accept that, as we said at the outset. Substantially is the test. But, of course, what's forbidden is that you can make claims to an entire range of products, and none of which can be achieved. A similar point Malone and friends make by reference to the second decision of the enlarged board, which is disclaimer PPG G103 at paragraph 73, which is MS 149. Again, this is totally consistent with our submissions. One can simply take the quote here that they've set out in their case. Either there is a large number of conceivable alternatives and the specification contains sufficient information on the relevant criteria for finding appropriate alternatives over the claimed range with reasonable effort. If this is the case, the inclusion of non-working embodiments is of no harm. In other words, you've enabled across the scope, but there might be the odd little island in the middle that you can't do, but you've got perfectly feasible alternatives. And then so on and so forth. This is all of a piece we submit with our overall contentions. Can I turn to the references in the UK authorities to principles of general application? And we start with Biogen, and we will submit that when properly read, all those cases are, including Biogen, are entirely consistent with our case. Biogen is at A1, tab 5, MS 932. We need to start at the top of page 47. MS 978, and the reference to an enabling disclosure. And as Lord Hoffman says here, the concept of an enabling disclosure is central to the law of patents, and sets out the basics of the section and the ground of revocation at 923 onwards. If we move on, we will see over the page at 48, MS 979, there's a reference to what the concept of an enabling disclosure means, and a misinterpretation of what the TBA said in Genentech polypeptide. And we'll look at polypeptide in a moment, but the misinterpretation to which he's referring is the false understanding of the courts that I'd referred to earlier in Molniker and Chiron, that this case represented authority for the proposition that a single enabled embodiment would be sufficient to support a broad claim. And he goes through that authority, and you will see what he says about polypeptide, to avoid going back to it, between 25 and 30. The general principle that had been invented in that case for enabling plasmids to control the expression of polypeptides in bacteria, there was no reason to believe it wouldn't work equally well with any plasmid, bacterium, or polypeptide. And when we look at what the TBA in Detergents Unilever said about the case, we see that the TBA take the view that in polypeptide there was no difficulty, so far as the skilled person is concerned, in getting this invention to work right across the scope of the claim with any plasmid and with any bacteria, which was known at the time. And that's why the patent, as he says, was granted in general terms. There's then a reference to the misunderstanding of that authority between 30 and 40, and he then characterizes the finding in polypeptide in a way which is perfectly correct if properly understood. First of all, he says they were simply applying the principle of patent law that the specification must enable the invention to be performed to the full extent of the monopoly claimed. He then says in the next sentence, if the invention discloses a principle capable of general application, the claims may be in correspondingly general terms. The patentee need not show he's proved its application in every individual instance. On the other hand, they include a number of discrete products. The patentee must enable the invention to be performed in respect of each of them. Now, just parsing that paragraph a little, if we recall what's meant by what he says in the first sentence, enable the invention to be performed to the full extent of the monopoly claimed, you will recall a little earlier we looked at Lord Walker's speech in Generics and Lundbeck, that in the case of a product claim, performing the invention meant making the product. That's paragraph 20 of Generics and Lundbeck. At tab 13 of 8 authorities 2. Someone will give me the I think we've been there already, so Lordship should have the note. And indeed, that Lord Hoffman said exactly the same thing himself in the Court of Appeal in that case, tab 12, paragraph 30. So, if performing the invention means making the product, performing the invention to the full extent of the monopoly claim plainly means making the products across the whole scope of the claim. The statement, if the invention discloses a principle capable of general application, the claims may be in correspondingly general terms, can only be referring to a principle which properly enables the skilled person to manufacture across the scope of the claim. We noted in our written case that when the Court of Appeal came to replicate this passage, they inserted the word but between those two sentences, which kind of suggested that one was an exception to the other. Plainly, that may have resulted in a misunderstanding of what this passage is all about. But in our submission, what it means is simply that if you have a principle which does properly enable across the scope of the claim, you can have more claims. And you don't then, as a question of fact or evidence, have to prove the fact that it works in every individual case, as he goes on to say. But if you haven't got such a principle which the skilled team would be able to apply generally to make everything, then you've got to give multiple disclosures of different methods of production. This is consistent with what Lord Hoffman actually goes on to say at page 51 of the same case, MS 982, at the top of the page, where he refers to the circumstances in which breadth of the claim exceeds the technical contribution, and he's looking at Article 83. The patent may claim results which it does not enable, such as making a wide class of products, when it enables only one of those products, and discloses no principle which would enable others to be made. We submit that that is key. When he's talking about a principle of application, he's talking about the principle which would actually enable the manufacture of the products across the scope of the claim. He is not, as the Court of Appeal appear to have thought he was, presenting it as some kind of exception to the general rule. The other passage we should look at briefly is top of 49 in Biogen, which is also relied on by my learned friends. He says, if the patentee has hit upon a new product which has a beneficial effect, but cannot demonstrate there's a common principle by which that effect will be shared, he'll be entitled to a patent by the product, but not for the class, even though some may subsequently turn out to have the same beneficial effect. On the other hand, and he quotes a case called May and Baker. On the other hand, if he's disclosed a beneficial property which is common to the class, he will be entitled to a patent for all products of that class, assuming them to be new, even though he has not himself made more than one or two of them. Now, one has to be a little careful with this passage, because plainly, in our submission, if what he's left the skilled reader with is a puzzle whereby he is simply not able to make the products across the scope of the class, he wouldn't be entitled to a patent. It's inconceivable, we submit, given what Lord Hoffman said at the top of page 51, that he can have intended to mean anything contrary to that. The reference to May and Baker is to an old authority under the pre-1949 Act, not about insufficiency at all, but about the therapeutic effect of certain compounds. In order to satisfy the requirements of the law, the therapeutic effect needed to be proved. But there was no issue in that case about whether the compounds could be made. So it's a bit like the second medical use type cases, where the courts are, because it's a feature of the claim, they're looking at the therapeutic effect and whether it is enabled across the scope of the class. We submit that Lord Hoffman here must simply be assuming, as the court was doing in May and Baker, that the skilled person could in fact make the product. The only problem was proving whether they had the therapeutic effect in question.
Are you going to come on to what Lord Hoffman later said about his judgment in Biogen?
Yes.
Right.
So if I can now, thank you, my lord.
Was May and Baker in fact a medical use case?
I'm sorry, my lord.
Was May and Baker in fact a medical use case?
In the context of the old law, yes, it was. In that, no. Yes. Yeah. I'm reminded by Mr. Taffet. I think under that law, the products were not claimable in their own right. But although the therapeutic effect was not a feature of the claim, in order to be able to claim the products, you did need to be able to prove the therapeutic effect. It was just a feature of the law as it was under the 1907 to 1949 Act. It's a very complicated case, which nobody's taken to you to, because it's a bit of a rabbit hole to chase down.
Because at first sight, it seems slightly strange to see Lord Hoffman stepping into the concept of its beneficial effect.
Yes.
In a discussion which is otherwise about sufficiency.
Yes.
At least if your general submissions are correct.
Well, my lord, in a second medical use case you would do, and in many cases that come before the courts you have to. But in those cases generally, of course the feature would be a feature of the claim. Why he's gone back to May and Baker is a bit of a mystery. It was obviously cited to him, and he thought it was useful. But he rose back, as we'll see, very much from this whole idea of principle of general application in Kiran Amgen, in the passage we're about to look at. But we submit the correct statement of the law in Biogen can be found between 50 and 51, MS 981 to 982. On page 50 from line 36, he refers to the concept of delivering the goods across the full width of the patent. And for that purpose, he's talking about the ability to actually make the two antigens HBCAG and HBsAg, the core and the surface antigens, which were the subject of the claim. So to deliver the goods, you had to actually enable the skilled person to make those two. And he plainly took the view that the Court of Appeal's reversal of the trial judge to hold that the manufacture of those was not enabled should be reversed, but ultimately found it wasn't necessary because there were other problems on sufficiency which this patent suffered from.
So that's a prerequisite, and this is an add-on.
What he's talking about in this paragraph from 36 through to 40 is a prerequisite of sufficiency, you have to deliver the goods by enabling the product. And what he goes on then to deal with is what used to be called the biogen insufficiency. That is to say, had you enabled all ways of making the product? A point that we now know is not good law for ordinary product claims, but is good law, in this jurisdiction at least, for product by process claims like biogen. And then if we, so that passage leads on to the next paragraph referring to Genentech polypeptide expression between 50 and 51, which is where, as we've said, Lord Hoffman expressly says that claiming results you don't enable, such as making a wide class of products, when you only enable one of them, that would be enabling the core antigen but not the surface, or vice versa, and disclosing no principle which would enable others to be made, renders your patent invalid for lack of sufficiency. And we say that is a correct statement of the law. In Kirin Amgen, which is at, we've got, I don't know where that is, tab 16 of volume 2, the authorities. He went back to what page? This is the one where he talks about
Page 202.
yeah, sorry,
566.
I lost my reference. Page 202
MS 1569.
of tab 16, which is MS 1569. There was a lengthy discussion, as one can see, from paragraph 112 about what amounted to a principle of general application. And helpfully or unhelpfully, he says, in my opinion, there's nothing difficult or mysterious about it. It simply means an element of the claim, which is stated in general terms. Such a claim is sufficiently enabled if one can reasonably expect the invention to work with anything which falls within the general terms. And then he refers to Genentech polypeptide and appears to be saying that the terms plasmid and bacterial host and sequence of exogenous DNA, or whatever the equivalent wording in the claim was, were principles of general application because they were simply elements within the claim stated in general terms, all of which could be used. There was no difficulty. In fact, as the Technical Board of Appeal found, they would all work. And then he goes on to elide that with something very simple or humble, he says in 113, such as a reference within a claim to a requirement of connecting means, which is enabled if the invention can reasonably be expected to work with any means of connection. Patentee doesn't have to have experimented with all of them. I mean, this really is reducing the idea of a concept of a principle of general application to features within a claim which are stated in a reasonably abstract way, such as connecting means, but which can perfectly well be enabled. Plainly, in a mechanical patent, you will commonly find references within the claim to things being joined by connecting means, and you will expect, in 99% of cases, that the skilled person will have no difficulty in selecting within a vast range of connecting means the ones which are perfectly suitable for implementing the invention. And this is entirely uncontroversial. What he isn't saying is anything like the broad submission which is now being made by Regeneron, which appears to be followed by the Court of Appeal, that if you can characterise your claim in a way which is an overarching principle and identify a benefit that anything within it should have if it could be made, then that is enough to avoid any difficulties on enablement. So we submit this is all a bit of a diversion and an irrelevance to the fundamental question, which is whether the principle as stated in the TBA authorities has been satisfied on the facts of the case. In parallel with this concept of a principle of general application, we also see references by the Court of Appeal and by Regeneron to technical contribution, bringing in the concept that sufficiency requires the claim to reflect the technical contribution of the patentee, and therefore, if one can characterise the technical contribution in very broad terms, then one can have a very broad claim. Put as broadly as that, without engaging in what we mean when we talk about technical contribution, we don't have too much difficulty with the proposition. But the key point is to understand what technical contribution means in the context of the law of sufficiency. And there are two particular points I want to make. The first is it is well established that the quality of the invention or the degree of inventiveness which underlies it is not relevant to the technical question of enablement. We've already seen paragraph 3.6 of Exxon on this, and I won't go back to that, but the point is made, in fact, in Unilever stable bleachers, which is A4 tab 30,
Have you finished with principle of general application?
Lord, yes.
Oh, you weren't going to take us to Lord Hoffman in Lundbeck, his own discussion of Biogen at paragraph 35.
I could do, well, Lord, yes.
Well-
Let's do that. I may have referred to this in passing a little earlier. Is this in
You took us to paragraph 34 this morning.
I beg your pardon. Tab 12 of Bundle A2, MS 1256. Yes. Sorry, well, I should have taken you to that. What happened, as I alluded to, following Biogen, was that it was misinterpreted by a number of judges as meaning that if you had a product claim, you needed to have enabled all methods of making the product, even though the methods were not themselves the subject of the claim at all. And what happened in Lundbeck was that the judge at first instance, Justice Kitchen, followed that interpretation and held that therefore you couldn't have a claim to a particular chemical entity when you'd only provided a single method of making it, because you had, as it were, claimed that product however it had been arrived at. And the Court of Appeal in the House of Lords said that was wrong. They said if it was a pure product claim with no method features in it, there was no method to enable. You simply had to provide a mechanism whereby the single product could be made. And this is what Lord Hoffman's getting at in the Court of Appeal, that the decision in Biogen was limited to the form of claim that the House of Lords was there considering. In other words, because it was, as it happened, a product by process claim, the burden on sufficiency was higher. You had to enable not only the products across the breadth of the claim, but also all the processes of making them across the breadth of the claim. That's what he's saying in 35. He says it's true that in Biogen the statement in Exxon corresponding to the technical contribution is needed, but it was a mistake here, and this I think also goes on to the point I'm now about to make, in treating the relevant contribution to the art as being the inventive step, namely a way of making the enantiomer. So the difficulty in Lundbeck was that the enantiomer was a known, predictable product, but it hadn't been made. And it could therefore have been said, standing back, that the clever bit was providing a way of actually making it. But what the Court of Appeal and the House of Lords said was that's the wrong way to look at a claim. You don't stand back and identify a freestanding inventive contribution. You look at the claim and you say, simply as a question of fact, has that been enabled? And that's what we say is the right approach to a case like this as well. It's no good saying, well, we've invented this idea of reducing immunological sickness, because that's got nothing to do with the claim. It might be the ultimate aim of your claim. It might be your clever recognition, but it isn't the claim itself. So he says the judge's interpretation of Biogen was a mistake. When a product claim satisfies the requirements of Section 1, the technical contribution is the product and not the process by which it's made, even if that process was the only inventive step. In other words, the claims are the be-all and end-all here for sufficiency.
And so in our case, are you saying the claim one is a transgenic mouse with certain characteristics? Yes. So you say that's the product?
That's a product, a range of mice. As it happens, they have to be made artificially, so there may be an additional sufficiency requirement in that respect, but that's not something with which you need be concerned. But certainly the products have to be, which are the subject of the claim, have to be enabled across the whole scope.
He says the technical
Yeah.
product. That's in the case.
Yeah. Yes. As my friend Mr. Tappin points out, if one puts paragraph 36 of Lundbeck next to the passage on page 51 we looked at in Biogen, you see where the technical contribution in a product claim is a product.
That's when it can be made.
One has to assume it can be made, and then it will be sufficient. But what Lord Hoffman said in Biogen, as we've seen, is that claiming a wide class of products but only enabling one of them to be made will render your patent invalid. Because it exceeds the technical contribution. And that's a good point, I think, to get on to this question of technical contribution, if I can. There were really 2 points, quick points to make. The first is quality of the invention not being relevant to the question of enablement. And I was going to take you briefly to Unilever's stable bleachers on this subject at A4, tab 30, page 9, paragraph 9, MS 2278. This was a case where the claim had been found invalid as not being enabled under Article 83, as you'll see at the bottom of paragraph 8. But interestingly, the board went on to say it's got the impression, it's tentatively admitted by one of the appellants, that if the filament composition had been reproducibly successful, it would indeed have been a very impressive invention. But the question of inventive step has become irrelevant in view of the above findings. In other words, it's got nothing to do with the question of sufficiency. In fact, I think Lord Hoffman made the same point in Generics and Lundbeck just after the... Well, in fact, I think we've already seen it in paragraph 36. It's got nothing to do with the inventive step. And he said the same thing at paragraph 41 in Generics and Lundbeck, MS 1257. There is nothing in section 72(1)(c) which connects the requirement of sufficiency to the inventive step. What needs to be disclosed sufficiently to enable it to be performed is the invention as defined in the claim. That remains the same, whatever may have been the inventive step. So one's not stepping outside the claim, looking at some kind of big picture about what's clever, how clever it is, or anything else. You simply look at the claim. You ask as a question of fact. Secondly, when the TBA talk about technical contribution in the context of sufficiency, they make it absolutely clear that technical contribution is not about simply having the idea. It involves inherently enabling the idea. There are a number of references to that. The first is Detergents Unilever at A434, page 8. Bottom of the page. MS, 2348. And there the TBA are explaining that the necessity of enablement is based, this is about 10 lines up, on the general legal principle that the protection covered by a patent should correspond to the technical contribution made by the disclosure of the invention. And they go on, which excludes that the patent monopoly be extended to subject matter which after reading would not be at the disposal of the skilled person. So in the context of Article 83, technical contribution requires enablement. It is part of the technical contribution to enable, which fits one's ordinary understanding, as we've said, of the patent bargain. Exactly the same thing in Mycogen over the tab 35 at paragraph, on page 18 at paragraph 5 of the decision, which is MS 2383. And between the two paragraphs, it's talking about Article 84 and Article 83, and 3 lines up from the bottom of the first paragraph. Both these requirements reflect the same general principle, namely the scope of the granted patent should correspond to its technical contribution to the state of the art. Hence it follows that despite being supported by the description from a formal point of view, claims are not allowable if they encompass subject matter which can only be performed with undue burden, etc. So corresponding to the technical contribution means not stepping outside what you have enabled. It's not a get out of jail free card if you haven't enabled. Exactly the same thing, ENG 103, which is one of my learned friends' authorities at A5 43, 2.5.3, MS 2663.
2662.
Sorry, 2662. Misprint. 2662 to 3, I think it should be.
Sorry, 26.
2662
to 3.
over to 2663. So this is the technical board, the enlarged Board of Appeal. The requirement of sufficiency ensures that a patent is only granted if there's a corresponding contribution to the state of the art. Such a contribution is not present as long as the person skilled in the art isn't able to carry out the invention. So it's fundamentally tied to the requirement of enablement. It's not an exception to it. We had the same thing from Lord Hoffman as we looked at. And then finally, molecular imprinted contact lenses, A5 tab 41, pages 14 to 15 at 3.8. MS 2591 to 2592. This is perhaps quite an important passage. With regard to the appellant's arguments concerning the technical contribution and the breadth of the claims, the board notes, in accordance with established jurisprudence, doesn't dispute the breadth of a claim is not in itself a sufficient reason for insufficiency. However, the principle of just reward or fair and adequate protection for the technical contribution on which the applicant relied requires that an applicant provide sufficient instruction to readily perform the invention without due burden, etc. And then, after reciting the technical contribution, advancing the known technology to a biomimetic molecular imprinting technique, in the board's judgment, to fulfil the requirement of sufficiency of disclosure, the application must provide a skilled person sufficient guidance to be able to achieve the result over the whole breadth of the claims. So, time and time again, technical contribution linked explicitly to that requirement of enablement. And both the Court of Appeal and Regeneron here, we commit a logical fallacy, because by denuding the idea of the technical contribution from the concept of enablement, they permit the technical contribution to be defined as something which is inherently non-enabling in the present case.
But if you stand back and look at the whole patent bargain, the bargain is that you have to meet novelty, you have to meet inventive step, and you have to meet enablement.
Yes.
And that is the technical contribution that gives you your monopoly.
Yes. And essentially they're trying to hive off one of those, saying because we've done a really good job on the others, it's novel and it's a great idea, please reward us by giving us a broad monopoly.
Yeah, I mean you could be rewarded if you patented the method.
Absolutely.
But then you wouldn't have a monopoly of the end product.
No. Or you can monopolise the scope of the products that you have properly enabled. Or you can wait until you have finalised everything that you think you can do, made all the necessary inventions, and apply for the lot. Or you can apply in chunks. You can get the bit that you have enabled, do some more work, and then get the rest of it with a proper disclosure.
Putting it in entirely untechnical language, you have to show not only that it's a great new idea, but that it works.
That it can be worked.
It can be.
Yes. To avoid getting into that semantic contradiction. Yes. So that's technical contribution. I should deal with the other point that's made, which is an argument based on inventive alternatives, and in particular the reliance by my own friends on the polypeptide expression case, and what was said there, a point also mentioned by the Court of Appeal. We call it the inventive improvement point. And both Regeneron and the Court of Appeal place emphasis on the point. The claim isn't invalid just because it covers inventive improvements which might be made in the future. And this is a point made in a number of cases, but including polypeptide expression Genentech. But what they do is they leap from the proposition that the fact that inventive improvements might be made in the future to your invention, to the proposition that you can leave entire chunks of the scope of your claim unachievable and simply rely on further inventions being made by readers of the specification in order to put them into effect. We submit that this really is not a particularly helpful point for Regeneron. Obviously, it can't be right to refuse a patent claim simply because of the possibilities that inventions might be made in the future of further useful features to bolt onto the invention, or the fact that one could apply the invention to future unknown products. Otherwise, essentially no claims would be allowable. It doesn't follow, as a matter of logic or common sense, that a claim must be valid despite the fact that the inadequacy of the disclosure is such that you have to make further inventions before you can perform it across its breadth at all. Otherwise, the requirement of enablement across the scope would be meaningless because it would be an answer in every case. For example, Exxon would simply say, well, we've enabled one way, obviously the rest are inventive improvements, so it's okay. We submit the differences between a situation where there can be improvements as useful bonuses to pre-existing enablements across the scope, and where the improvement is a necessity to achieve enablement across the scope. We've referred in our written case to Lord Hoffman and Kirin Amgen, dismissing arguments of this kind at A2, tab 16, paragraph 117. It might be worth just pulling that up briefly. That's MS 1569, it's page 202 in the report. Exactly the same argument was made, in fact, by the Court of Appeal in that case, as you can see in paragraph 110, which is the page before 201, MS 1568. If you look at the end of that paragraph, that this was all to do with whether the claims were too broad because they covered processes like the TKT process, which the defendants were using. As you see, Lord Justice Aldous essentially said, well, TKT is an inventive improvement, and that's okay. The law or otherwise would be no room for patents which disclose the principle of general application unless the specification described how to carry it out. At 117, correct as far as it goes, choice of a particular form of antigen may improve the way the invention works be itself an inventive step. Specification isn't insufficient merely because it doesn't enable the person to make such an invention. But TKT doesn't rely on the fact the use of TKT, even endogenous gene, was inventive. Their objection is it's not a way of making EPO which is disclosed, even in the most general terms, by the specification. But the breadth of claim rejection may well have been a good one. In other words, you've still got to enable across the scope, and the fact that something, you can posit the possibility of making inventions is neither here nor there. And finally, on this point, if I may, a good instance of the distinction between the instance where there is an inventive improvement, which is covered by the claim, and where the claim simply doesn't enable whole chunks of the scope of the monopoly at all, is Regeneron and Genentech, which the Court of Appeal themselves cite between 246 and 249. And if you've got volume A3, you'll see an instance of, you'll see how that worked. A3 somewhere. I'll stay through. So that's MS 1900. It's tab 22, and it's paragraphs 167 to 168. I don't want to spend too long on it because it's technically a little bit dense, but the point is a relatively straightforward one. This was, the point in this case was, as perhaps if you turn back to the head note at 1858, MS 1858, the patent related to certain agents called VEGF, VEGF antagonists for the treatment of various diseases. Regeneron were in fact the defendants there, the appellant, who developed something called VEGF trap, and they were trying to say it didn't infringe the patent. VEGF trap was an example of a chimeric product, and the question was whether chimeric products fell within the claim. And you'll see it from 167 of the judgment, 1900 onwards. The argument was that chimeric receptors generally were not shown to have the characteristics of the claim, and if they were within the claim, then the claim was invalid for insufficiency, and VEGF trap was an example of a chimeric receptor. What the Court of Appeal conclude, as you see at 172, is that the skilled team would have regarded, this is MS 1901, the skilled team would have regarded chimeric molecules as variants falling within the scope of the claim. So they did fall within the scope. The skilled team would have had them well in mind in the light of the teaching, and would have been able to produce such molecules across the scope of the claim without any great difficulty. That is not to say they could have produced VEGF trap, for I accept this would have required a good deal of ingenuity. This does not mean the patent is insufficient, because VEGF trap essentially was, although it embodied the technical contribution, was an inventive improvement. If, of course, the patentee had not enabled the production of chimeric molecules at all, they would have constituted a distinct segment of the claim which was simply not enabled. And the finding by the Court of Appeal that chimeric molecules generally were enabled meant that the claim survived. VEGF trap was a very particular inventive instance of chimeric molecules, therefore didn't, on its own, render the claim bad for lack of sufficiency. So we say the inventive improvement point is really nothing to do with the present case, where the vast bulk of the claim is simply not enabled. Can I briefly then go to the section in the Court of Appeal judgment? Do you think I need to? Yeah. Okay. Before I do that, I'm reminded I did mean to show you in relation to the polypeptide case how it was characterised by the Technical Board of Appeal in the later case of Unilever detergents. Because one of the friends placed quite a heavy reliance on it in a suggestion that it was, on the face of it, a claim where it wasn't enabled across its breadth, and though nonetheless was allowed, it's characterised in Detergents Unilever at tab 34 of A4 in a passage between MS 2350 and MS 232, which is in 2352, which is in paragraph 2.2.2 between pages 10 and 11. And you'll see from the bottom of page 10, this was dealing with the argument that disclosure of one way of carrying out the invention would be sufficient. They note that it's not adequate to take the finding in polypeptide expression out of its context. Not only they're stated that, and that's the at least one way is clearly indicating, but in the next sentence it's made clear that any non-availability of some particular variants is immaterial to sufficiency as long as there are suitable variants known to the skilled person through the disclosure of common general knowledge which will provide the same effect for the invention. Accordingly, this decision is inter alia based on the finding of fact that the application concerned made enough choice of suitable variants of the specifically disclosed embodiments available. Moreover, in respect to the functional expression suitable bacterium, was pointed out the applicability to the claim method to any kind or most species of bacteria has not been effectively challenged. Similar findings of fact concern the remaining functional definitions in the considered claim. And that is why in 2.2.3 they are able to reconcile polypeptide expression with their statement of the law on sufficiency. Only exceptional failures, they say there, can be tolerated. But in polypeptide, there was no more than a risk of exceptional failures because on the facts as found in that case, the invention simply worked and could have been used with any examples of bacteria or plasmids which the skilled person had chosen. It was, therefore, on any view, properly enabled across its breadth. Their conclusion on polypeptide is at 2.2.3, on polypeptide and all the other decisions which are reconciled, is at 2.2.3, about 10 lines down, all based on the common ground. And then we go on to the expectation that all embodiments can be put into practice. In other words, only exceptional failures can be tolerated. So there is nothing magic about polypeptide. It is not in any way inconsistent with the fundamental principles expressed by the TBA in later cases. I was going to wrap this, my submissions up by looking briefly at the Court of Appeals judgment from 230 onwards, where one can see where they went our submission badly wrong. And we are here at MS 228 paragraph 230, where they characterise the law of sufficiency by reference to the various decisions of the Boards of Appeal. And we say fundamentally, they kick off with Lord Justice Jacob's statement in 230 from Novartis, which is absolutely right in our submission and the correct characterisation in pithy terms of the requirement of enablement across the scope. Can the skilled person readily perform the invention over the whole area without undue burden, without needing inventive skill? Then they say that is of course true, but in our judgment it's apparent from looking at the decisions of the TBA, and in assessing whether the skilled person can adequately perform the invention, we can look at other matters. And if we just look at the points they make, 231, we agree, we've dealt with, I think, only substantially all embodiments across the whole breadth of the claim need to be made. The inventive improvements exception is, as we've explained, irrelevant to the present case, and certain exceptions are permissible, although it doesn't mean you don't have to enable whole rafts of the claim scope. 232, sensitive to the nature of the invention. Well, yes, in the sense that the claim is the invention. But if they're saying that it's something beyond the claim that is contrary to all the authorities we've looked at, and it's almost here as if they are saying that, general methodology or general application, it's permissible to claim it in general terms, even though the specification doesn't enable every way of arriving at its subject matter. Well, of course, this, of course, is not our case. This is mischaracterizing our case, as they do later on, as being an argument of the type that failed in Generics and Lundbeck. Our problem is not you haven't enabled every way, it's that substantial chunks of the claim can't be achieved. And thirdly, they make the point about technical contribution to the art, but in such broad terms that they utterly depart from any proper consideration of what the technical contribution means in the context of sufficiency. And we've looked at all the authorities that tie it directly to the requirement of enablement. We submit there's nothing that justifies a departure from the basic statement made by Lord Justice Jacob. Had they stuck with that statement, they would have had to say the answer is no, and that the patent is duly invalid. They go on from paragraph 260 to make a series of similar points, starting at 255 on MS 237. First of all, they take into account, on the face of it, the major contribution of the art, i.e. the inventive step of the reverse chimeric locus, and the immunological sickness. Neither of those in our submission are relevant to the question they had to decide on sufficiency, and it supports my suggestion that they were seduced by the apparent success of the product in later years. The character of the invention is then stated in 256 by reference to benefiting from the technical contribution. Once again, the basis of everything I've said, this is irrelevant to the question of enablement. This is simply asking whether there will be a benefit if they could be made, and the benefit is something that is not even the subject of the claim. 257 and 258 is their finding of a very limited enablement. 259 is their recognition, and the first sentence is key, that those mice would have had only a subset of the human V gene segments. That should have been sufficient for them to stop and say the claim is therefore invalid. And then 260 is their conclusory paragraph, where in our submission they conflate a range of irrelevant matters. Character is one of general application, and there's a reference to benefit, for the same reason I've given before. A skilled person would reasonably expect the invention to work across the scope of the claim. Well, that's the problem with the word work. It couldn't be worked in the sense of not being able to be made, and therefore it's pretty hard to see how it would work. What is more, there's nothing in the claim which could have been envisaged without the invention. Well, since the invention and the claim are the same thing, that's a somewhat strange comment, but essentially they seem to be coming back to the question of obviousness. And then there's a policy point they make at the end, which for the reasons we've given in the case is not sustainable and simply not relevant when considering the application of the principles of law in this area. In our submission, the Court of Appeal have simply departed from what is a pretty straightforward and basic principle of sufficiency without due cause. Finally, yes, Mr. Tappin reminds me at 267, they come back full circle to a conclusion that Claim 1 of 163 doesn't exceed the contribution to the art which the disclosure of its specification has made. Given what we have said about technical contribution, that is plainly not the case. Technical contribution requires enablement, and on that basis they appear to conclude that it is adequately enabled across its scope in our submission. It is certainly not fully enabled across its scope as required by the laws. My Lords, I've come to the end of my timed session. The only point I've left unmentioned is the relatively brief question of policy considerations, but if I may, I'll leave that until I've heard from our Lord Panning.
Yes, very well. Mr. Tappin, to follow. Lord Panic.
My Lords, my Lady, the case for Regeneron can be summarised in 8 propositions. Can I identify them and then seek to develop them tomorrow? First of all, the law of sufficiency, like other aspects of patent law, is designed to ensure that the patent monopoly corresponds to and is justified by the technical contribution to the art. And what Mr. Purvis described at the outset of his submissions as the song of the siren is in our submission more accurately described as the fundamental principle of patent law in the context of sufficiency as in all other contexts, as I shall seek to show the court. Second proposition is whether the test of sufficiency is satisfied depends on the invention in the particular case, and it depends on whether the content of the claim has been sufficiently disclosed. That's the principle stated by Lord Hoffman in Lundbeck, paragraph 29, to which my friend referred. It was MS 1255. I don't ask the court to turn it up now. It's the sentence: in order to decide whether the specification is sufficient, it's first necessary to decide what the invention is. That must be found by reading and construing the claims. So it depends, is the second proposition. The third proposition is that in this case, Regeneron has invented what the Court of Appeal recognised, it's paragraph 39 of the judgment, MS 183, to be, I quote, a striking, radical and highly original departure in the art, unquote. And the invention is, and the claim is to transgenic mice with the reverse chimeric locus. That is, mice which, as the court has heard, retain the murine constant region but they have the human variable regions inserted in that locus. And the effect is that those mice avoid the immunological sickness of the prior art mice. And of course, without the reverse chimeric element, the prior art mice were unable efficiently to produce human antibodies, diverse or otherwise. The Court of Appeal held, it's paragraph 99 at MS 196, that the reverse chimeric locus has become, I quote, the gold standard for in vivo antibody production. The fourth point I will make is that Claim 1 of Patent 163, which my friend rightly focuses upon, is a claim to a product. It's a claim to a transgenic mouse with a reverse chimeric locus. The reverse chimeric locus is part of the physical features of the claimed mouse. And the technical contribution is that feature. It has the effect, this is its significance, it has the effect of removing the immunological sickness of the prior art mice, as I've mentioned. It is not a claim, and this is very important, it's not a claim to a product produced by the insertion of a specifically defined quantity of DNA. And we'll see that in the claim when we look at it. And indeed, the quantity of DNA inserted, how many V's, how many J's, how many D's, does not affect the immunological sickness of prior art mice. And it doesn't affect the curing of the immunological sickness in the mouse which embodies the reverse chimeric locus. That's not the claim. The claim is and is only, as I'll show the court, to a mouse with the reverse chimeric locus. The fifth point is we say the breadth of the patent claim is commensurate with, and it is justified by the technical contribution in the claim which has been disclosed. And we do not accept that the claim is broad in any pejorative sense. The claim is no broader than our contribution to the art. The sixth point, and this is the heart of the case, we say the requirement of sufficiency does not mean, it does not require, that the patent must disclose information to enable a person skilled in the art to make every product across the scope of the claim. And whereas here the claim is to an invention of a principle of general application, that is a mouse with the reverse chimeric locus that has the effect for which I have contended and which the Court of Appeal found, the requirement of sufficiency is satisfied by the disclosure of sufficient information to enable the skilled person to make at least one embodiment of the claimed invention, which the Court of Appeal here found to be the case, and also sufficient information that the skilled person can reasonably expect that the invention will work across the scope of the claim, which again the Court of Appeal found to be the case, every mouse with these features, the features claimed, has the beneficial effect. In this context, that suffices to enable the invention across the scope of the claim. Our case is not that we are absolved from the requirement of enablement. The question is, what does enablement require? In a context such as this, where there is a product with a specific feature which operates as a general principle across the scope of the claim. And the question is really a question to which Lord Hoffmann adverted in Biogen. It was at MS 797 at the top of page 48. Again, no need to turn it up at this stage. Lord Hoffmann said, what has been less clear is what the concept of an enabling disclosure means. That's the question in this case. Not that there's no need to enable, but what does it mean in the context of a case such as this?
And the feature of a product which you say is the principle of general application is that the transgenic mouse possesses a reverse chimeric locus.
Yes. Yes. And your lordship will see my friend, and I don't criticise him, he didn't take the court to the claim, but when we look at the claim, we'll see that is precisely and only what is claimed in Claim 1 of Patent 163. That's the sixth point. The seventh point is that Kymab's approach, the approach my friend has very eloquently developed, that patent protection applies only if the patentee has disclosed information that allows a person skilled in the art to make everything that falls within the scope of the claim as at priority date, although he accepts there might be exceptions at the edges, but that's his general point. You've got to be able to make everything. His approach in our submission would frustrate the purposes of patent law. And it would frustrate the purposes of patent law because the Court of Appeal accepted, again, I don't ask the court to turn it up now, but it was paragraph 255 at MS 237, that we have disclosed, quote, a major contribution to the arts, which, quote, provides the answer to a significant problem which those working in the field have faced, namely that transgenic mice produced by conventional methods were immunologically sick, unquote. We say that if we do not receive patent protection commensurate with that disclosure, Kymab's approach would deter companies from spending the time and the money needed to produce such innovation, and would deter disclosure of such technical contributions. That's the seventh point. It's the policy point, which my friend said, understandably, from his point of view, he wanted to reserve his position on. We say it's absolutely fundamental to the approach that is adopted to the law of sufficiency. And eighth, and this is the final point, but it's a very important part of our case, we say that unsurprisingly, given the policy implications, the case law in the courts of this jurisdiction and in the European Patent Office, the EPO Board of Appeals, the case law supports our approach to the law of sufficiency. The case law recognises that a patent claim can be sufficiently enabled, depends on the facts of the case, but it can be sufficiently enabled, albeit not all embodiments can be made as at priority date, provided that the claim is to a principle of general application which will work across the scope of the claim. That's the technical contribution, then that the patent law recognises it and supports it.
I just asked that will work as at the priority date.
Well, will work not in the sense that it can be made, but it will work in the sense that any mouse with the reverse chimeric locus will avoid the immunological sickness. It's a different question whether it can be made as at patent, as at priority date, but the technical contribution is a valid, effective technical contribution in scientific terms. It's not purely theoretical because you need to show at least one embodiment of the principle. And that's what we've done. But it's sufficient in our submission to show at least one embodiment, this is what the cases say, as long as there is a general principle that is being claimed and disclosed. Those are the 7 points, the 8 points that I wanted to identify, and which I'm going to develop. In seeking permission to appeal in this case, Kymab said, perhaps we could just look at this. This is in Core Volume 1, Tab 1, at page MS, page 20. They said in paragraph 1, in the decision under appeal, the Court of Appeal upheld a broad patent monopoly over genetically engineered mice, which are used for the production of human antibodies to fight dangerous diseases. Although the technology involved is complex, it is not necessary to explain it in any detail in order to address the issues raised on this appeal. And I respectfully agree with that. The issue is an issue of law, as identified in the latter part of my friend's submissions. But I'm going to leave, if I may, sufficient time for my co-counsel, Mr. Speck, to not just add observations on the topics I'm addressing, although of course he won't repeat points that the court already has, but I want to leave time for him to address the court and answer any questions from the court on two main areas. First of all, the details of the scientific innovation which is at the heart of the patent claim, and secondly, the scientific details of the patents which were in issue in the case law, in the domestic courts and in the Board of Appeal applying the EPC, which we're going to look at. Now, I say the starting point here is the principle stated by my Lord the Deputy President for this court in Actavis. And although it's very familiar to your lordships and your ladyship, it's important just to have it in mind. So could I take the court to Authorities Volume 1, Tab 1, MS 772, and the relevant passage begins at MS 787, and it's paragraph 53, where my Lord, speaking for the court, on page 1333 of the law report, MS 787, paragraph 53, since the enactment of the Statute of Monopolies, which prohibited the grant of monopoly by the Crown, but created an exception for a patent, the purpose of a grant of a patent has been to encourage innovation. We emphasise that. The monopoly granted by the patent rewards the inventor by enabling him or her to charge a higher price than would have been possible if there'd been competition. The patent bargain is this: the inventor obtains a monopoly in return for disclosing the invention and dedicating it to the public for use after the monopoly has expired. Now, that's not a statute, but that's the point. Have we disclosed the invention? Here, a very special type of invention, as I shall seek to persuade the court. And then at paragraph 54, third line, my Lord referred to the Technical Board of Appeal decision in Agravol Triazoles, where it said it has for long been a generally accepted legal principle that the extent of the patent monopoly should correspond to and be justified by the technical contribution to the art. This general legal principle was applied in relation to the extent of the patent protection that was justified by reference to the requirements of Article 83 and 84. The same legal principle also governs the decision required to be made under Article 56. My friend's written case suggested that there was somehow a distinction between Article 83 and 84. My friend hasn't developed that point today. To the extent it's relied upon, that's the first example of the general principle applying in both contexts, and we'll see that regularly repeated. Over the page at MS 788, paragraph 56, there's a reference to how the jurisprudence of our courts, although not bound to do so, should normally follow the settled jurisprudence of the EPO, and that, of course, is what Section 130, subsection 7 of the Patents Act requires in the interests of uniformity. And then at 57, my Lord says it's the general principle that the extent of the patent monopoly should correspond to and be justified by the actual technical contribution to the art is thus part of the jurisprudence of both the EPO and the UK courts, and as Lord Sumption observed in generics, the principal conditions of validity, novelty, inventive step, industrial application, and I emphasise these words, and sufficiency are all in one way or another directed to satisfying the principle thus expressed. There is therefore a balance or symmetry in patent law, as my friend Mr. Speck submitted. So this general principle is a principle of the law of sufficiency. It's not the only relevant factor, but it's an important factor in identifying what sufficiency requires. So we say that's the starting point, and a very important starting point, because our case is that the Court of Appeal were rightly anxious to ensure that in the circumstances of this case, the patent monopoly does correspond to and is commensurate with the technical contribution to the art which has been disclosed by Regeneron. Can I next turn to what we say, and I'll deal with this very speedily, is not or should not be in dispute in this appeal. First, there cannot now be any dispute that the invention by Regeneron, by its President and Chief Scientific Officer, Dr. Yankopoulos, is novel, it's inventive, and it is significant. That was disputed by Kymab at trial, but unsuccessfully. And as I've indicated, the problem addressed by the invention was that the prior art mice were inefficient in producing antibodies. They were immunologically sick, as the Court of Appeal said at paragraph 34, MS 182, in that they were inefficient in producing antibodies. Dr. Yankopoulos identified the cause and the cure for that sickness. He realized that the problem was that transgenic mice were having inserted into them both parts of the human genes, that is the variable part and the constant part. He realized the solution was to retain the murine constant region genes and to insert only the human variable region genes in the same locus, and that's known as the reverse chimeric locus. And the mice embodying the reverse chimeric locus were not afflicted with this immunological sickness, and the prior art mice were immunologically sick irrespective of the number of V's, D's and J's which were inserted. Paragraph 39 of the Court of Appeal judgment, which the court will find at MS 183, invite the court just to look at this. This is where they say this is a striking, radical and highly original departure in the art. And they say that for the reasons that they set out in some detail at 34 through to 38. They describe the immunological sickness at 34. At 35, they describe how no scientist had previously thought of this solution. At 36, the judge, Mr. Justice Henry Carr, it's at paragraph 99, MS 292, found that those skilled in the art at that time, their thinking was unidirectional, narrowly focused, myopically obsessed, one might say, with the production of human antibodies. The Court of Appeal explained the novelty and the significance, and at paragraph 235 of the judgment, 255 of the judgment, which is MS 237, they say that the disclosure of the reverse chimeric locus was, as we've described, a major contribution to the art. It provided the answer to a significant problem which those working in the field had faced, namely that transgenic mice produced by conventional methods were immunologically sick. Transgenic mice with the reverse chimeric locus do not suffer from this deficiency. And one other reference, which is on MS 196, at paragraph 99, MS 196, the reverse chimeric locus was not only a striking, radical and highly original departure in the art, but Regeneron's mouse with this locus has now become the gold standard for in vivo antibody production, as Dr. Yankopoulos explained in his unchallenged evidence. The question is whether we are entitled to patent protection for such a significant innovation. The second matter, which is or should not be in dispute, is that the invention, the mouse with the reverse chimeric locus, can reasonably be expected to work across the scope of the claim. Not that it can be made, but that it has the beneficial effects across the scope of the claim. And that is the Court of Appeal at paragraph 256. MS 237, my lords, my lady. MS 237, paragraph 256, where the Court of Appeal say this: the character of this invention is therefore such that any transgenic mouse which falls within the scope of the claim and so produces hybrid antibodies containing the human variable regions and mouse constant regions will benefit from the technical contribution the disclosure of the 163 patent has made to the art, and will do so irrespective of the antigen which is used to challenge the mouse. In our judgment, it is properly described as a principle of general application. And of course, there's no challenge, there cannot be a challenge in this court to any of these scientific findings. That is the basis on which the case comes to this court. My friends sought to appeal from the Court of Appeal on some facts, the court may recall, in relation to whether or not the invention could be worked at all. and the court refused permission to appeal on that question. I'll come to that. But there was no attempt to appeal against these findings. So that's the second matter which should not be in dispute. This is an invention that works across the scope of the claim. It applies to any mouse which is embodied the reverse chimeric locus. It has the effects that I have described. That's the second matter.
The scope of the claim and whether it's to be described as principle of general application are not matters of science, but matters of law.
No, indeed, it's for your lordship to decide, of course. My point is...
Because you said these are matters which aren't in dispute. Well, they're fundamentally...
The facts are not in dispute. That's what I meant. All I mean, my lord, is that the facts are not in dispute. That is that the transgenic mouse that embodies the reverse chimeric locus will in all cases avoid the immunological sickness which afflicted prior art mice. Of course, I entirely accept, and I didn't mean to go further than this, it's still nevertheless, of course, for your lordships and your ladyship to determine what is the consequence of that for the law of sufficiency. I was coming to a third matter, but I noticed the time. I'm in the court's hands. Happy to continue, of course, tomorrow.
I think we can wait patiently until tomorrow morning, no panic.